What was your prior career before?
Additional.
And after you completed your
As a patrol.
as a police officer,
Yes.
did you respond to calls for service and write police reports?
Yes. Lots of calls for service and lots of reports.
After you left the Tallahassee Police Department, you took a job with, was it the Department of Education?
Yes, Florida's Department of Education as an investigator in their Inspector General's office.
Please describe your general duties there.
So as an investigator, I was charged with investigating waste, fraud, and abuse within and affecting the Department of Education. The investigations were both administrative, for example, sexual harassment allegations, within the Department of Education, and also criminal, private school tuition voucher fraud primarily, although there were some other non-tuition voucher fraud criminal cases that I was involved in.
When did you decide to go to law school and enter law school?
Having put my undergraduate education on hold as an investigator, I now had a regular day job, so I was able to finish that degree. It took me 10 years to get a 4-year degree because I can be a little slower than the average bear sometimes. As I was coming up on the end of that degree, we made the decision, my wife and I made the decision to go to law school to continue to expand career options.
Where did you attend law school?
The University of Virginia.
And what year did you graduate from law school?
2011.
And at what point did you enter academia generally?
I clerked for a year after law school. I worked for a federal judge based out of Indiana for the year after law school. I then began my academic fellowship after that clerkship.
And in your academic pursuits, did you decided to build on the experience that you had as a former police officer?
Yes.
And how so?
As I began law school, I really had no intention of becoming an academic. And I had some outstanding professors, and between their influence and my interest in studying policing from an academic and a legal perspective, I realized there was a little bit of a niche where I could draw on some of the information that I had from firsthand experience to either ask questions that other academics maybe had not asked, or to find answers in different places that other academics may not have thought to look.
And is that where you've focused your research?
Yes, all of my research has been on policing and the regulation of policing.
Have you authored any scholarly publications?
Yes.
And what sort of publications have you authored?
I have written law review articles, which is the type of academic journal that legal scholars publish in. I've written for a number of different publishers, a number of different articles on a range of topics, officers and off-duty employment, the use of force, tactics, different ways that aspects of our legal system regulate police officers and affect officer behaviors.
Have you authored chapters of books?
Yes, I have.
What books, what publications have you authored chapters of?
I think my most recent publication was in Critical Issues in Policing, which is a series of contemporary essays on policing. That chapter is on the regulation of police violence. I've authored book chapters on police misconduct, and I'm authoring another one on use of force review right now.
You published a book recently, is that right? You co-authored a book, is that right?
Yes, I did.
And what's the title of the book?
That's Evaluating Police Uses of Force.
All right, and you have a copy with you here.
I do.
You co-authored that book with Jeffrey Noble and Jeffrey Alpert, is that right?
Yes, that's correct.
So are you a member of any professional organizations?
I am, yes.
What professional organizations are you a member of?
I'm an associate member of the Virginia Bar, which is a non-practicing member of the State Bar Association for attorneys. I'm a member of the American Society of Evidence-Based Policing, a member of the International Association of Chiefs of Police. I serve as an advisor to the American Law Institute's Principles of the Law on Policing, I'm a member, or I believe technically a liaison, to the American Bar Association's working group on trust in the criminal justice system. There are probably a couple of other ones. I don't remember them all offhand.
Do you occasionally provide consultation to law enforcement agencies in conducting use of force reviews through these organizations?
Not through the professional organizations, but I do work with, consult or do research with police agencies, yes.
Does that include providing educational instruction?
Yes.
Consultation?
Yes, it has.
And specific use of force reviews?
It has, yes.
And what agencies have you done that kind of work with?
I've done a training presentation to the training officers in the Richland County Sheriff's Office, which is, I believe, the largest law enforcement agency in South Carolina. I'm a member of the Civilian Advisory Council with my local police department, the Columbia Police Department. So I sit in what are called command review boards, which can involve assessing use of force in that context. I've done presentations and training at the Federal Law Enforcement Training Center, which is not an agency per se, but the audience had representatives of a number of different state, local, and federal agencies. I've provided training and presentations to the Bureau of Alcohol, Tobacco, Firearms, and Explosives senior staff, to the command staff of the Kansas City, Missouri Police Department. All of those are sort of formal. There might be a couple of others, as well as a range of informal consultations and discussions on a range of issues with a number of agencies.
And are you a frequent speaker or lecturer on issues of policing and uses of force throughout the country?
Yes, although in the past year most of those have been presentations from my home via Zoom, but yes, they are based all over the place.
What organizations do you present to?
I've presented well over 100 times at this point to organizations that include the American Judges Association, the Conference of Chief Justices, judicial conferences in a number of states, prosecution or defense conferences in a number of states, security conference in Mexico City, a prosecution and defense combined conference in Canada. Most recently, I've presented at several law reviews and symposiums, one hosted by by Loyola University in Chicago. That was this past week. By the Journal of Criminal Law and Criminology. That was the week before, I believe. By the University of Wisconsin, Plattsville. That was also in this past week.
Right. Have you previously been retained as an expert witness?
Yes, I have.
How often have you been retained as an expert witness?
I've been retained around 60 times at this point.
Okay. Have you testified as an expert witness before at a deposition?
Yes, I have.
Okay. Approximately how many times?
At deposition, I think over a dozen, pretty easily at this point, I believe.
And in those depositions, have you testified as an expert witness in the area of use of force?
Yes, tactics, use of force, police procedure, yes.
Have you testified at a trial before as an expert in use of force?
Yes, I have. Use of force, including tactics and use of force related issues, yes.
What courts have you testified in?
There was a federal court in North Carolina, a federal court in South Carolina, criminal court in Georgia. I think that's it for trial testimony. As you know, most of these, most cases don't actually make it to a trial. Yep.
And you were talking about depositions. Those are civil cases, is that right?
Yes, that's correct.
All right. Now, you've been retained in this matter to provide testimony regarding the use of force that occurred on May 25, 2020 in the matter of the death of George Floyd. Is that correct?
Yes, I have.
Okay. And having been retained, you charge a fee for your services?
For my time in review, yes.
All right. What is your fee, your hourly rate?
$295 an hour in this case.
And you receive a different rate for trial days?
I have a 8-hour minimum on days I'm expected to testify, yes.
Okay. And to date, how much have you been compensated based on your work in this case?
I would have to look at my records to see what actual compensation has been. In the area of maybe $24,000 or $25,000 received.
How many hours would you estimate that you've put into preparing for this matter?
Including both compensated and uncompensated hours, I'm probably in this might be overestimating slightly, but in the 130 to 140 hour range.
Now, in your experience as an expert witness, have you always reached a conclusion that's favorable to the party who hires you?
No.
Why is that?
Because the facts and my review of the facts did not favor them. So my credibility is very important to me, and if I am retained and develop an opinion that does not favor the attorney who retains me, that's still my opinion.
Now, did you actively seek to participate in this matter?
No.
Who contacted you?
The state of Minnesota.
Based upon in your retention with the state of Minnesota, have you developed opinions regarding the use of force against George Floyd on the date of his death?
Yes, and related activity, yes.
I'd like you to please explain to the jury first the process by which you go about reaching conclusions, analyzing cases such as this.
Sure. So the first step is to get and go through the material. In this case, I believe I got an external hard drive that had tens of thousands of pages of documentation. I believe close to or over 40,000 pages of documentation, a large number of videos, including a number of body-worn camera videos, including the body-worn camera videos of the officers who were involved in this particular incident.
Those would include the body-worn camera videos of the defendant, is that right?
Yes.
And Officer Tao, Officer King, and Officer Lane?
Yes.
Did you also review some bystander videos, Darnella Frazier, for example?
Yes. Her video, Ms. Hansen's video, a video taken from across the street by a bystander, I think in a Speedway gas station. A traffic cam or a pole camera mounted somewhere up above. Yes, a number of videos. As
an individual who frequently reviews uses of force, are you commonly called upon to review body-worn camera footage and other footage such as surveillance or bystander video?
Yes. In fact, one of my academic publications is specifically about body-worn cameras, and I've done a great deal of both research and teaching on using video footage, interpreting video footage, especially in use of force cases.
If you could please describe to the jury just I guess the depth of body-worn camera footage you were able to view in this case as compared to one in which you might have just a single recording. Yeah, sure. It's pretty common for a use of force to only involve an officer or two, to involve very limited video, maybe only the video from that particular officer. And body-worn camera or any video footage is just one more piece of evidence that I, in conducting a review,
have to examine and weigh and measure against other pieces of evidence. In this case, unlike the vast majority of cases that I've been involved in, there were a whole bunch of videos. So videos from different perspectives of the same event that can allow a much more robust understanding of what was going on. To put it very simply, one camera only captures what's available on that camera. So I don't see what's happening off camera. But when I have multiple videos from multiple perspectives, multiple angles, it allows me to get a much better sense of what's happening when and where.
So using some examples, you examined the Frazier video, is that right?
Yes.
And you were also able to view the Alicia Finari, the Speedway employee's video as well, correct?
Yes, that's correct.
And then at the same time view the Milestone video, the larger overview.
Yes, that's the pole camera video, I think on top or near the top of the Speedway. And
can you describe to the jury the different perspectives that you were able to see using each of those videos and how the viewing of one aided the understanding of the other?
Sure. So very simply, the Ms. Frazier's video was taken from the sidewalk near the squad, near the police vehicle. And you really don't see officers Lane or King on that video. On the other hand, from the perspective across the street at the Speedway or the pole camera, you do see those officers. It's simply because the camera isn't obstructed by the police vehicle.
Now, did you, upon your review of all the videos, the documents that you discussed, complete a report memorializing your findings?
Yes, I did. My findings and opinions.
About how long was that report?
The report total, I believe, was close to 300 pages. That includes a rather lengthy appendix that lists out all of the materials that I reviewed. The body of the report itself, which has my summary of the relevant facts and my opinions, was, I think, about 112 pages. 110 pages if we take out the table of contents, maybe. Over 100 pages.
All right. And did you rely on your training and your experience and academic experience to review the evidence in this case and reach your conclusions?
Yes.
And have you reached your opinions to a degree of reasonable professional certainty based on generally accepted standards in your field?
Yes, I have.
Now, before sharing those opinions, sir, I would like you to please explain what factors you review when you're evaluating uses of force.
Sure. So first, as sort of a threshold point, I have to know what I'm actually looking at, right? I have to know which uses of force I'm actually reviewing. For example, if an officer is involved in a shooting, the saying is the officer has to account for every bullet that they put downrange. That is, they count as separate uses of force. After I identify what the uses of force are, then I apply essentially a four-step analytical framework. First, I identify what the relevant facts and circumstances are as viewed through the lens of a reasonable officer on the scene. Then I assess the threat, if any, presented by the individual's actions. Then I assess the foreseeable effects of the officer's use of force. And then the fourth step is sort of putting all of that together and assessing whether, in light of the facts and circumstances, the foreseeable effects of the officer's use of force were justified and reasonable because they were proportional and appropriate in light of the threat presented by the individual's actions.
By what standard are you making this assessment?
So the ultimate analytical question, that step 4, is applying generally accepted police practices, what we might call a national or professional standard for the way we expect and the way policing expects officers to engage with individuals and use force.
And what are these national standards based on?
So a combination of things. They're certainly influenced by constitutional law, for example, by history and research in policing. Since the 1970s or so, there's been tactical research within policing that's helped inform what we would now consider generally accepted practices, a great deal of evidence and experience as well.
Are there constitutional standards as well?
Yes, constitutional law, especially the Fourth Amendment standard, is one of the factors that defines or certainly influences generally accepted practices.
Is another influence a particular department's policies and training?
An agency's policies or training might, and indeed I would hope they are, reflective of the generally accepted practices, but we can't define industry-wide generally accepted practices by looking at a particular agency's policies or training.
So the standard you're reviewing is that of reasonableness.
That's correct. Now, we might look at a large number of agencies and say, okay, if hundreds or many, many police agencies are doing this thing, then maybe that's a best practice or a generally accepted practice. But you can't just look at one agency and say it's reasonable because this one agency said it was reasonable.
All right. When discussing the constitutional standards, you're familiar with the standards set forth in Graham versus Connor?
I am, yes.
And you have a demonstrative, I believe it's Exhibit 954. And if I could publish that, the Graham factors.
Okay. 954 is received for demonstrative purposes only.
Right. And can you just please tell the jury what it is you see here?
So this is a summary of what are referred to as the Graham factors. These are specific factors identified by the Supreme Court in the case Graham v. Connor that we use really in that second phase of analysis. And the second step, remember, is assessing the threat presented by the individual's actions. And to understand Graham v. Connor, kind of have to understand what we mean by threat. First, when we're talking about the threat that an individual may present, it's not some abstract notion. It's not general threat or conceptual. It's specific threat of something, right? Someone who's running away may present a threat of escape or a threat of assaulting an officer or the like. And further, we can define threat. We know that threat exists when the individual has the physical ability and the opportunity and the inherent intention to cause whatever specific harm we're analyzing. So, for example, imagine someone who's just standing there with nothing in their hands. They don't have the physical ability to hit an officer with a tire iron. So there's no threat that an officer is going to be hit with a tire iron. There's just no physical ability there. On the other hand, imagine someone who has a tire iron but who's 50 feet away. They have the physical ability because they have a tire iron, but they don't have any opportunity. They're too far away in that moment to actually present a threat. And then we could imagine someone who has a tire iron and they're 2 or 3 feet away from an officer, but they're changing a tire at the time. They have the ability and the opportunity, but there's nothing about that interaction, as the officer is talking with them, that suggests they have the apparent intention to cause that particular threat. So when you put all of those three things together, ability, opportunity, and intention, that's how we identify threat. The Graham-Connor...
I'd like you to contrast that with risk.
Oh, sure. So threat, as I've defined it, can be contrasted with risk. Risk you can think of as a potential threat. That person with the tire iron who's 50 feet away, they don't present a threat. If they get close enough, they might have the opportunity now or the apparent intention to strike an officer with the tire iron, but they don't yet. So risk is something that officers can use tactics and communication to help address. The goal is to prevent risk from becoming threat and really to prevent threat from becoming whatever that relevant harm is. But while threat can justify use of force, risk can't. An officer can't use force on someone who's holding a tire iron and 2 or 3 feet away while they're just changing a tire because there's no apparent intention, there's no threat there. The officer can do something like back away, build distance so they aren't 2 or 3 feet away, or interpose the vehicle between themselves and the individual they're interacting with. or use communications. They could ask the individual to put the tire iron down, but they can't use force there because there's no threat.
I'm sorry to interrupt you.
This is what you get for having a law professor testify.
And they're trying so hard to take notes, and the court reporter's trying to take things down, so I'm going to slow you down a little bit, if I may, Professor.
Sure, sorry.
Oh, no problem. Then in assessing other potential risk factors, would you agree that the relative size of a person is a risk factor?
It's certainly a relevant consideration, yes.
But is it in and of itself a threat?
No, certainly not. Someone who's physically large may have a greater physical ability to inflict harm if they assault an officer, but that their size can't establish opportunity and can't establish intention.
And how about recent drug use? Is that a threat or a risk?
Again, it's a relevant consideration, but it does not in and of itself establish a threat. It doesn't establish physical ability by itself to do anything. It doesn't establish opportunity to do anything, nor does it establish apparent intention. So it's certainly a relevant consideration in the totality of the circumstances, but officers can't use force on someone just because they're on drugs.
Now, I'd like to talk about, or I'd like you to discuss the severity of the crime at issue. How is that relevant to the Graham analysis?
Sure. So as we're thinking about the concept of threat, the Graham factors really help us identify when there's a threat and how much of a threat. Severity of the crime can be best understood as a proxy for dangerousness. All other things being equal, an armed bank robber may be suspected to be more dangerous than someone who is cashing a worthless check, for example. So severity of the crime is really a proxy for evaluating how much risk someone might present, how dangerous are they.
And if we could go to the third factor then, the active resistance, whether they are actively resisting arrest or attempting to evade arrest by flight. How is that relevant to your analysis?
So again, this is all part of that threat analysis, that second step in my framework. And this is getting at the behavior of the subject. So for example, someone who's attempting to evade arrest by flight is threatening the government's interest in apprehending that person. It's about identifying a threat of escape. Active resistance can be similar. It's a threat of someone frustrating the government's interest in taking them into custody, for example.
Are there different types of resistance?
Yes, absolutely.
What are the types, generally accepted definitions in policing as the different types of resistance?
Sure. So the concepts are certainly generally accepted, although some of the vocabulary differs from place to place. We might first identify someone who is compliant, who's doing what the officers want, no resistance at all, right? Then we might have someone who is passive or non-compliant. They're not doing what the officers want, but they're not doing anything against what the officers are telling them to do either. The classic example of passive resistance is someone who's just laying on the ground, refusing to get up when told. Then there's active resistance, which is typically defined as someone who is engaging their muscles in some way. Someone who's tensing up or someone who's running away is engaged in active resistance. Next level up, if we can say that, is active aggression. And this is where someone is not just engaging their muscles, they're engaging their muscles in a way that creates a threat of harm to the officers or someone else. And finally, the ultimate expression of active aggression is when a subject presents an imminent threat, again, as that term is defined, of death or serious bodily injury to officers or others.
Okay. If we could take that down, please. Now, I think we've gone through in a little more detail the first two steps of your four-step process. Talk about identifying facts that would have been apparent to a reasonable officer. You've discussed identifying threats. You also testify that you need to identify the foreseeable effects of the officer's actions. Can you explain what you mean by that?
Absolutely. What I mean by the foreseeable effects of the officer's actions is essentially what is this use of force likely to do? Just as there's a spectrum of resistance from no resistance to a whole lot of resistance, right, threatening the life of an officer, there's also a spectrum of effects that we might expect from an officer's use of force. So, for example, some uses of force are relatively minor and unlikely to cause any more than temporary discomfort. Other uses of force are substantially likely to cause death or serious bodily injury, what we would refer to as deadly force. As you're analyzing use of force, it's very important to focus on the foreseeable effects of what the use of force involved, and not the actual effects, not what actually happened. And I can give you an easy example. If an officer shoots at someone, that's a use of deadly force because it's foreseeable that discharging a firearm at someone is going to cause death or serious bodily injury. And that's true even if the officer misses entirely, or if the bullet hits the person but causes a very superficial injury. Let's say it just scrapes them. It's still a use of deadly force because of the foreseeable effects, not the actual effects. And that concept of foreseeable effect is what's foreseeable really at the time force is being used.
And Professor Stoughton, the fourth factor that you testified about, determining whether the officer's actions are appropriate, proportional, and reasonable. Can you please explain what you mean by appropriate, proportional, and reasonable?
Yes, so what we're talking about is sort of a balancing of harms here. This also pulls from Graham v. Connor and the Fourth Amendment standard, which talked about balancing the individual interest against the government interest. The idea is an officer cannot use more force than the situation justifies. That is, the foreseeable effects of the officer's use of force can't be disproportionate to the threat presented by the individual's actions.
And sir, did you take all of these factors into consideration in your performing your analysis in this case?
Absolutely, yes.
Ask if you assisted with the preparation of a demonstrative exhibit, demonstrative 953.
Yes, I did.
And would the use of that demonstrative exhibit assist you in explaining your analysis and testimony to the jury?
Yes, and especially how those factors apply.
Offer exhibit 953 for demonstrative purposes.
Any objection? 953 is received for demonstrative purposes only.
And before we publish that, first I'd like to publish what's been received as exhibit 17 and ask you, sir, if you identified in accordance with your process what particular force you evaluated. So if you would publish exhibit 17.
Yeah, so there are two components to the use of force here. The first is the defendant's knee or shin over Mr. Floyd's neck. The second is Mr. Floyd in that prone position while restrained, what I may refer to as prone restraint.
At this time, I'd like to publish exhibit 953. One moment, Your Honor. Did you also look at a demonstrative exhibit, exhibit 949, that showed the relative position of the defendant and the other officers on Mr. Floyd?
Yes, I did.
All right.
And again, here you can see the two components of the use of force, the knee across Mr. Floyd's neck, as well as him being in the prone or face-down position while restrained.
I'm offering exhibit 949 for demonstrative purposes.
For demonstrative purposes, no.
949 is received for demonstrative purposes only.
And using what you saw as exhibit 17, which has been received substantively in 949, again, explain what particular force you are analyzing and over what period of time.
Yeah, so again, both the prior image, the photograph, and this this demonstrative show the knee, the defendant's knee across the back of Mr. Floyd's neck, and Mr. Floyd face down in that prone position while handcuffed. The use of force here, use of force is not always a flash-in-the-pan event. Firing a bullet might be, but other uses of force, including the uses of force in this case, are sustained. So they start when Mr. Floyd is put into the prone position and when the knee goes across the neck, and the uses of force continue until the knee comes off the neck and Mr. Floyd is taken out of that prone position.
And you indicated that the use of force included the defendant's placement of the knee on the neck. The other knee, where did that appear to be placed?
Yes, variously on Mr. Floyd's upper arm, shoulder, or upper back.
Okay.
I would put that, for purposes I imagine we will discuss, as part of holding Mr. Floyd in the prone position while restrained.
What was your determination of the duration of this restraint period?
From the time Mr. Floyd was initially placed in the prone position, 9 minutes and approximately 29 seconds until the knee was taken off of his neck and he was taken out of that prone position. And
did you determine this period of time based on your review of using Officer King's body-worn camera footage starting at 20:19:14 and ending at 20:28:43?
Yes, that's correct.
And is it your testimony that, according to national standards, the use of force must be reasonable when it starts, and it must continue to be reasonable during the entire duration?
Objection,
Sustained. Rephrase.
And, sir, can you make any comment about how long the particular use of force must be reasonable as in the defined restraint period?
Yes, so a use of force that is sustained over a period of time does have to be reasonable at the time force is initiated. That is when force is first used and throughout the duration that force is being used.
And I believe you testified that using and applying these national and constitutional standards is viewed through the eyes of what a reasonable police officer at the scene. Is that correct?
That's correct. That's part of the Graham v. Connor framework, as well as certainly has been adopted into generally accepted police practices.
So then, using your four-step analysis to identify relevant facts and circumstances that would have been apparent to a reasonable officer on the scene, would you please summarize for the jury, based on your review, what information would have been available to a reasonable police officer in the defendant's position prior to his arrival at the scene that day?
Yes. So the reasonable officer on the scene standard is an objective one. We don't just adopt an officer's idiosyncratic subjective perspective. We take the reasonable officer and put them into the actual officer's position and say, what would the reasonable officer have perceived, seen, heard, or believed? In this case, prior to the reasonable officer in the defendant's position arriving on scene, he would have been aware that there was a call, I believe, dispatched about counterfeiting, that the individual was described as possibly intoxicated. The individual later identified as Mr. Floyd was identified as possibly intoxicated, that two other officers had taken the call, had, I believe, taken someone into custody and called Code 4, identified that they had the scene under control and did not need additional resources.
Now what I'd like to do is turning to the demonstrative 953. Right, you can see the beginning of this use of force evaluation, and you have this divided into different sections. Up top you have threat factors, at the bottom you have foreseeable effects of force, you have the defendant and his conduct up top, activity of Mr. Floyd on the bottom. Is that right?
Yes, the threat factors are really the behaviors of Mr. Floyd and whether they presented any threat. And the foreseeable effects of force are really about the effects of the use of force on Mr. Floyd. Yes.
Now, what I'd like to do at this time is show you a first clip. This is taken from what has been received into evidence as Exhibit 45. beginning at timestamp 20:17:40. And you see on the demonstrative here, it says defendant arrives on the scene. I'd like to publish that clip first.
Just the chair.
You can't win. I'm not trying to win. Go on, get in the car then. I didn't drown anything. Go on, get in the car. Get in the car. He know it. He know it too, Mr. Officer. Y'all hear me? Don't do me like that, man. Please. Okay, can I talk to you, please? So you get in the car. We can talk. I am claustrophobic. I'm hearing you, but you're not working with me. God, I'm claustrophobic. Get in the car. Get in the car. Get me in the front. Please. No, you're not in the front. I'm claustrophobic, Mr. Officer. Get in the car. Okay. I'm not a bad guy, man. Get in the car. I'm not a bad guy. You ain't gonna win.
All right. Now, sir, this is taken from the perspective of the defendant's body-worn camera. Is that right?
Yes, it is.
What information would have been apparent to a reasonable officer based on the exchange we just observed?
So a reasonable officer in the defendant's position would have realized that Mr. Floyd was in handcuffs, would have realized that there were 2 MPD officers already on scene, along with 2 more now, the defendant and the officer that he arrived with, would have realized that there was what we might call a point of conflict between the officers and Mr. Floyd, who did not want to get into the back of the car. One of the things that signifies is generally that, generally that the individual has been searched. Typically, an officer is not going to load someone into a squad into the back of a car until after they've been searched. As I said, a reasonable officer would have seen that this appears to be a point of conflict, would have heard that Mr. Floyd was describing himself as claustrophobic, would have understood Mr. Floyd to be offering some alternatives, right? Laying on the ground or sitting up in the front of the car, as opposed to being put in the back of the car. In other words, the point of contention does not appear to be police custody, right? Mr. Floyd does not appear to be objecting to being kept in police custody, but instead to be objecting to being put in the back of a vehicle.
Now, you're aware that the officers attempted to place him in the back of the vehicle, and he was eventually taken back out of the back of the vehicle and into the street. Is that right?
Yes, there was some non-compliance initially, and then what we would describe as that active resistance, what appears to be physical engagement of the muscles in a non-assaultive or non-aggressive way, leading ultimately to officers' decision to take him out of the rear passenger side of the vehicle.
And so, in your view, a reasonable officer would not have perceived this as active resistance, as an act of violence, or active aggression, I should say.
That's correct. This does not appear to be active aggression in the sense that Mr. Floyd does not appear to have the intention to assault or attack the officers here. His efforts appeared aimed at not being in the backseat of the car.
Now, I'd like to publish the second clip, clip 2, which is taken from Exhibit 43, which is Officer King's body-worn camera. And the footage begins at timestamp 20:19:01, and it's labeled Floyd placed prone. If you'd please publish that.
For what? Please, man. I can't fucking breathe. Here, come on out. Look at you. Thank you. Thank you. Get up off the ground.
Pause. All right. So we're paused here at mark 20:19:08. Is that right?
Yes.
Now, at this point, can you please describe what would have been apparent to a reasonable officer at the scene?
So, as you heard, Mr. Floyd has already said, I can't breathe, and as officers pull him out of the backseat of the car, again, that point of contention from earlier, you hear Mr. Floyd say, thank you.
And he is also appears to be handcuffed, is that right?
He is handcuffed, and I believe, although not entirely clear from this freeze frame, I believe the video will show that he's on his knees at this point.
If you'd resume playing clip, please.
Yeah, on the ground. On the ground. Ah, my piece.
You got your restraint, hobble. Okay. I'll grab that.
All right. Now, from that segment that we just watched, clip 2, can you please describe what information would have been available to a reasonable officer in the defendant's position at that time?
Yes. So again, focusing on the threat analysis here in this step, Mr. Floyd remains handcuffed. He's put from his position on his knees, where he's said, "Thank you, and I appreciate that," having been taken out of the back seat of the car. He's originally pushed over onto his left side, sort of facing the car, and then rolled from his left side into the prone position, into that face-down position.
Now, prior to having him, I guess, first brought down to the ground, at the time he was placed on his knees, I believe you indicated that he said, "I appreciate that," or "thank you," something to that effect?
Yes.
All right. At that point, was it necessary for the officers to prone him?
No.
Why,
It was not.
Why not?
Again, looking at the threat analysis here, it's clear from the number of officers and Mr. Floyd's position, the fact that he's handcuffed and has been searched, he doesn't present a threat of harm. His actions don't indicate that he presents any threat of escape. And as he's saying thank you for being taken out of the backseat of the car, it would certainly suggest that the point of conflict that had provoked his resistance in the first place is over. It suggests a lack of intention. Given the range of other alternatives available to the officers, it's just not appropriate to prone someone who is at that point cooperative.
What is the purpose of placing someone in the prone position in accordance with generally accepted police standards?
Yes, the prone position is a very useful position in policing for getting control of someone for purposes of handcuffing them. Again, the prone position is just basically face down, right? Their chest, front of the hips on the ground. When officers are struggling with someone, or when they're handcuffing someone who they anticipate struggling with, you'll often see officers put someone into that prone position for purposes of handcuffing, because it's very difficult for someone to fight or to resist as they're face down on the ground, especially once their arms are out at their sides. However, the prone position, as useful as it is for handcuffing, is supposed to be transitory. It's used for handcuffing, and then as soon as someone has been handcuffed, you take them out of that position for, I imagine, reasons that we'll discuss.
And the position that you take him out of and put him into, is that the side recovery position?
It is, yes.
If you could then, I'm just recalling the clip we saw initially when Mr. Floyd was on his knees and he was brought to the ground, what position was he in initially?
So initially, as he's on his knees, when he's brought over onto his left side, that would be consistent with the recovery position, laying on his side with his legs either straight or bent.
And then from that, essentially what would be the side recovery position, he was actually brought into the prone position from the recovery position. Is that right?
Yes, that's correct.
Right. And at this point, or shortly after this point, the prone position, the prone restraint position begins. Is that right?
Yes, when he is put into that prone position, that's where I would say that the prone restraint begins. He is restrained and prone.
Now,
as well as the knee across the neck. These are really the two uses of force that I'm focusing on.
all right, and this is where you've indicated as the beginning of the restraint period. Is that right?
That's correct. That red line indicates where the prone restraint and the knee across the neck begins in that timeline.
Now, I need to ask you, at the time that he was placed prone, when this use of force was done, was Mr. Floyd a threat?
So again, threat is specific, but I don't see him presenting a threat of anything. He was not a threat of harm to the officers, even to the extent he had physical ability. He didn't have much in the way of opportunity to assault or harm the officers, and just as importantly, there's no specific and articulable facts that an officer, a reasonable officer in the defendant's position could use to conclude that he had the intention of causing physical harm to the officers or others. It's very clear that although he had legs, so I suppose he had the physical ability to run away, he does not have the opportunity to do so. And again, there's no facts from which we could assess any intention to escape, so no threat of escape. And really, in light of the situation, there's not even a credible threat of obstructing the investigation. With 4 officers in the immediate area and one more, I believe a park police officer, maybe half a block away across the street, there are ample resources on scene to maintain control and custody of Mr. Floyd. 2 officers can stand with him, and the other 2 can go about doing the what was ultimately a forgery investigation.
And if we could go to the next clip, please. Right, and that clip is taken from what's been received as Exhibit 49, which is the body-worn camera of Officer Tao. Is that right?
Yes, it is.
And it starts at 20:21:31. If we could publish that, please.
I can't breathe, man. Please. Please let me stand. No. Please, man, I can't breathe.
Can you please explain to the jury what you heard and saw in this clip that's relevant to your analysis?
Yes, so there are a couple of things. First, of course, you hear Mr. Floyd saying that he can't breathe. That will come up as we talk about the foreseeable effects of the use of force. You'll also hear the officers discussing and ultimately concluding that they aren't going to use the Hobble restraint.
Did they discuss why they wouldn't use the Hobble restraint?
You hear, yes, you hear one of the officers say because something like, if we use the Hobble, a sergeant's going to have to come.
Now, can you please tell the jury what generally how a Hobble restraint system works and what it's for?
Yes, a Hobble is used to limit the motion of someone's legs. So if they're kicking or flailing around with the legs, especially someone who's in, for example, the backseat of a police car who may be kicking out the windows or something like that. And essentially the Hobble goes around the ankles and binds the ankles together and then is connected to a belt piece, sort of a component around the midsection to slightly bend the individual's legs. Historically, the legs used to be bent up behind someone. Think of laying on your stomach and then kicking your feet up towards your butt. The way hobbles are generally used now is the feet aren't behind the individual, they're just brought up, so the knees are kept in front of the body and brought up a little bit. Again, the point is just to make it much more difficult, if not impossible, for the individual to kick.
And what would a reasonable police officer on the scene use to determine whether a Hobble restraint is appropriate?
So hobbles are generally appropriate when officers cannot effectively restrain someone using only handcuffs. When they have someone who is continuing to kick or flail or flop around uncontrollably.
Is the absence or presence or the need to summon a supervisor an appropriate reason to either use or not use a Hobble?
No, if the situation justifies a Hobble, then officers should use the Hobble, regardless of the fact that that means a supervisor will have to respond. If the situation does not justify a Hobble, then they shouldn't use a Hobble, regardless of the requirement to summon a supervisor.
And would you agree that a Hobble is just sort of a brand name for a form of MRT or maximal restraint technique?
Yeah, so Hobble, 4-point restraint, maximal restraint. There are specific brands like the RIP Hobble But yeah, these are all essentially the same concept that we're talking about.
And was the application of force by the officers without the hobble essentially a maximal restraint technique, but without the use of that tool?
To the extent that the hobble would effectively immobilize someone and keep them from kicking, then what you see here is officers controlling Mr. Floyd's upper body, middle body, and lower body, which would keep him from kicking. So although not a perfect parallel, I would certainly describe it as a behavioral analog of a maximal restraint or a hobble-like technique.
And when an individual is placed in the maximal restraint, the hobble, are they supposed to be placed in the side recovery position?
Absolutely. Just like handcuffing, as soon as an individual is restrained, handcuffs or hobble, you get the person off of their stomach, out of the prone restraint and into a side recovery position.
And I'd like to then move to the next segment.
If I may, on
we can move to the next segment here. We're looking at the next clip, which is Exhibit 47, beginning at 20:23:47. If you would publish that, please.
Roll them on the side.
All right. Can you please, and you can move forward then next. Please explain to the jury what you heard that was relevant to your analysis in that exchange.
So there's one officer who's suggesting or asking about whether they should roll Mr. Floyd onto his side, and you hear the defendant say no, he's staying put, and they're going to keep him in the prone restraint.
Okay. And what was the significance of that?
It would indicate to a reasonable officer that at least one person there did not feel that Mr. Floyd presented the level of threat that required them to keep him in that prone restraint position, that at least one person was suggesting we can flip him onto his side, or should we flip him onto his side.
Okay. And if you could proceed to the next clip. And again, if you could play that segment, Exhibit 47 at 20:25:38.
Roll them on the side.
And move forward. And again, we heard a similar exchange. Is that right?
Yes, we did, along with one of the bystanders in the background saying he's not responsive right now. Both of those are factors to consider in identifying the threat that Mr. Floyd presented. If he's not responsive, obviously he can't present any threat, and the fact that you have an officer suggesting roll him onto his side, again, suggests the perception that officers are fully capable of maintaining custody and control of Mr. Floyd without keeping him in that prone restraint position.
Now, in accordance with your four-step process, the next step is to identify foreseeable effects of the officer's actions. Is that right?
Yes, that's correct.
You did that in this case. Is that right?
Yes.
And I'd like you to please discuss, if you could advance the slide here. Okay. Right, go ahead. We have some potential foreseeable effects. What does a reasonable officer have to take into account when determining what the potential foreseeable effects of their actions are?
Sure. So under that first step of the analysis, we look at the facts and circumstances as they would have been aware to a reasonable officer on the scene. And some of those facts and circumstances may indicate that there are specific foreseeable effects of force. So in this case, again, we have those two separate components of force that I'm going to address. One is the knee across the neck. That foreseeably can cause pretty significant, serious bodily injury or death. If you think of someone who's laying face down, where the head or face is against the ground and the chest is against the ground, that means the neck is kind of like a suspension bridge, right? So it's generally accepted in policing that you do not put weight down on someone's neck in that position because of the potential that the neck won't be able to handle that weight. and you can end up damaging the structures of the neck. That's kind of generic. There's nothing specific that we need in this case. That applies to all defendants. So I apologize, all individuals. There are also foreseeable effects of keeping someone in that prone position. Prominently, what's called positional asphyxia, someone who starts having trouble breathing, who can't take in over time the amount of oxygen that they need to sustain their life functions. This is something that's been very well known in policing for at least going on 30 years. The prone restraint position limits the ability of someone to breathe. And there are some additional specific factors relevant to this case that increase the susceptibility of Mr. Floyd to positional asphyxia, and that a reasonable officer would have known prior to the use of force. Specifically,
Ask another question.
And those additional risk factors, would those include the downward pressure of the weight of
Overruled.
the officers?
Yes, absolutely. Additional weight on a subject's back can further compromise their breathing, rendering them more susceptible to positional asphyxia.
Yep.
Apologies, Your Honor.
All right, at this time, I'm going to ask that the next clip 6, which is taken from Exhibit 49, which is, I believe, Tao's body-worn camera, and it starts at a timestamp 20:21:50. If you would play that, please.
What do you want? I can't breathe. Please, the knee in my neck. I can't breathe shit.
Well, get up, get in the car, man.
I will.
Get up, get in the car.
I can't move.
I've been wiping the whole.
Ah!
Get up, get in the car.
Mama,
Get up. Get
Mama,
in the car.
I can't.
Get
Up
y'all
here.
opportunity
Is that
to
the-
win, bro.
All right.
You can't win.
My knee,
You
my
can't
neck.
win, man.
And can you please explain, are we looking at a break? Were you signaling to me, Judge, that we...
I don't know. You tell me in the next 10 minutes when a good break is.
Oh, okay, thank you, Your Honor. With respect to this portion that we just viewed, what did you see that was relevant to your analysis with respect to potential foreseeable consequences of the officer's actions?
So two things really stand out. One is you hear Mr. Floyd saying that he can't breathe, and one of the indicators of susceptibility to positional asphyxia is that someone starts having difficulty breathing. The other component, one of the factors that can increase the susceptibility to positional asphyxia, is drug or alcohol intoxication. Even before the defendant arrived on scene, the counterfeiting suspect, who was later identified as Mr. Floyd, was described as possibly intoxicated. And here in this clip, you can hear the officers discussing the likelihood that he's intoxicated, that he was found with drug paraphernalia on him, and that they suspect there might be other drugs in play.
And there are other things that an officer can listen to, even including a report of distress from the person themselves. Is that right? Person upon whom force is being applied.
Absolutely. If someone is describing that they are experiencing medical distress, then officers have to take that into account as they're evaluating the continued effects of keeping someone in this case, a prone restraint position.
I'd like to play clip 7, which is taken from Exhibit 43, King's body-worn camera at 20:22:18. We publish.
I'm through. I'm through. I'm claustrophobic. My stomach hurts. My neck hurts. Everything hurts. Get some water or something. Please. Please. I can't breathe off.
Hey, do a lot of talking, a lot of
They
yelling.
will kill me. They will kill me, man.
Takes a heck of a lot of oxygen to say
Come on, man.
Now, during what we just viewed as clip 7, was the defendant, was the use of force the same as when you began analyzing this at point 0?
Yes, the officers are maintaining Mr. Floyd in that prone restraint position, but there are some additional indicators that the foreseeable effects of force are occurring, that he's experiencing positional asphyxia.
And did you hear Mr. Floyd say plainly that he was experiencing some form of medical distress?
Not only does he indicate it with the words he's using, saying that he can't breathe, but even compared to that prior clip, his voice is slower and thicker. So both what he is saying and how he is saying it would indicate an increased medical distress.
And would a reasonable officer on the scene then, hearing this, have at least been aware of the complaint?
Absolutely, especially when you hear an officer respond to that complaint, it's certainly an indication that an officer was aware of it.
Okay. And you reviewed these body-worn cameras on numerous occasions, is that right?
Yes, many times.
Did you have an opportunity to review body-worn camera in which the defendant's voice could be heard at the same time that you could see him as the speaker?
I believe there is, yes, he is identifiable as the speaker. I forget which body-worn camera that is, or maybe it's the comparison of multiple body-worn cameras, but he is identifiable as the speaker there.
And I'm sorry, and in the exchange we just heard, was he identifiable as the speaker who was saying, uh-huh?
Yes.
If we could go to clip 8, just taken from Exhibit 47 at 20:24:40.
Yeah, I think he's messing up.
And if you could advance, can you please explain to the jury what you heard and saw in that clip that's relevant to your analysis as to the foreseeable effects of force?
So the first thing you hear is one of the bystanders say he's passed out or something like that, and that's echoed by one of the officers who says he's passing out. As we're assessing, as we're assessing threat, if we can jump back to that for a second, someone who's passing out obviously does not present a threat. You don't hear Mr. Floyd, which is notable because until he stopped speaking, his vocalizations were kind of incessant, right? There weren't very many periods where he wasn't speaking until he wasn't. And you hear I'm sorry, back to the officer, you hear an officer saying he's passing out. That again indicates an increasing level now of medical distress.
And the officer who was stating this was in close proximity to the defendant at the time he was saying it, is that right?
He was. I believe this is Officer Lane, who is at Mr. Floyd's feet. So maybe of the officers who are on Mr. Floyd, maybe in the worst position to identify exactly what Mr. Floyd is going through, but still identifying that he's passing out.
In the clip that we just viewed at 20:24:40, that was approximately 40 seconds after a time that you've identified that Mr. Floyd had said, "I can't breathe," approximately 27 times. Is that the incessant speech you were talking about?
Yes. Before he fell silent, Mr. Floyd said, "I can't breathe," by my count, at least 27 times.
Now, if we can advance to the next clip. And I guess before we publish the next clip, which was from Exhibit 43 at 20:25:40, you made a notation here on the demonstrative exhibit regarding Mr. Floyd's movement and his speech. Is that right?
Yes, that's correct. So from approximately 4 minutes and 45 seconds after the prone restraint had begun, for the next 53 seconds, Mr. Floyd is silent. He's not saying anything, but he's still moving slightly.
And would this have been readily apparent to a reasonable officer at the defendant's vantage point at that particular moment?
Absolutely.
If we could publish the next clip.
Right now, he's not responsive right now, bro. No, bro, look at him. He's not responsive right now, bro. Bro, are you serious? He's not just trying to get with that on his neck, bro. Is he breathing right now? Check his pulse. Check his pulse. Check his pulse, Kyle. Kyle, check his pulse.
Suspect is sitting on the 20 to 30 years old. The victim is crying, and the suspect has a gun. He's pointing the gun at
What is that? What do you think that is? You call what he doing okay? You call what he doing okay?
And what did you see in that clip that was relevant to your foreseeable effective force analysis?
So here the audio starts with the bystanders saying that Mr. Floyd is not responsive, pleading with officers to check his pulse. Officer King does so, spends 6 or 7 seconds checking, looks like 2 locations, or maybe trying to get a pulse on the same location twice, before ultimately announcing that he can't find a pulse. At that point, the defendant says, huh, and Officer King clarifies and says, I was trying to find a pulse, or something like that.
Jumping up to the threat factors then, because we're looking at the same event as Mr. Floyd, presenting anybody a threat at this point?
No, someone who does not have a pulse does not present a threat in any way.
Now I'd like to advance to clip 11. Okay. Right, if you would publish that, please.
Not responsive right now. You guys might want to.
Right now.
And please tell the jury what you saw relevant to your analysis with respect to foreseeable effects.
So you hear Officer Lane describe Mr. Floyd as not responsive. This is as the paramedics are arriving, and Officer Lane is directing them by saying that Mr. Floyd is not responsive. Again, back up to the threat factors, certainly cannot be a threat if he's not responsive, and now even more indication that the use of force is having deleterious effects on Mr. Floyd's health.
Okay. And if we can advance to the next clip. Right. At a point, and I don't believe that's a, oh yes, actually go ahead and publish that. It's the Fraser video 202842, Exhibit 15.
The fact that you guys aren't checking his pulse and doing it.
And what is it you see here that was relevant to your analysis?
This is immediately before Mr. Floyd is loaded onto the stretcher, and you see the defendant take his knee off of Mr. Floyd, and shortly after that particular clip, Mr. Floyd is rolled and lifted onto the stretcher.
And so would that then mark the end of the restraint period at 9 minutes and 29 seconds?
Yes, it would.
Right. Your Honor.